Who may witness a will? Hi, I'm Darren Findling of the Probate Pro, and we know that in Michigan, to have a will that's non-holographic, the will has to be signed and witnessed by two individuals. So, who can witness the will? Well, the statute that governs it is quite broad. It's MCL 700.2505, and it says that an individual generally competent to be a witness may act as a witness to be in a will. And the signing of a will by an interested witness does not invalidate the will or any provision of it. So let's break this down. What makes somebody competent to be a witness so that they could then execute a will? Well, the Michigan Rules of Evidence indicate that essentially the witness must be able to truthfully recall the circumstances that the document was signed. Pretty broad. And of course, if the person is a child, a spouse, a family member, a creditor, an interested person in the affairs of the will, they can still witness it. Now, that doesn't mean you couldn't challenge the will because of undue influence or lack of capacity, but the mere fact that they're an interested person in the will does not, in and of itself, invalidate the will. In addition, a witness who is competent to witness the will at the time, who then later becomes incompetent, has no impact on the fact that they were competent at the time. So it doesn't matter what happens later on to them or if they happen to die. If they were competent at the time of the execution of the will, it's a valid witnessing. And of course, the question that then comes is, what does a witness do? Well, the witness is supposed to see the decedent signing the document or heard the decedent say or acknowledge that they signed the document at a later date. So it doesn't have to be at the exact moment. It can occur thereafter. And those are the basic requirements. So it's a pretty broad definition of witnessing requirements. Now, in litigation issues, the witnessing can be quite important to the veracity or whether the will becomes admitted to probate. So we always urge people to work with a skilled, competent probate practitioner because the witnessing requirements can be evidence of whether the will was executed appropriately. And we surely don't want to get embroiled in a long probate fight over a properly executed will. If you've got questions about probate-related issues, visit us at theprobatepro.com or call us at 1-833-PROBATE.